encourage people I want to encourage people to ask questions. So if you would, if when I'm talking, if you have a question, put up your little raise your hand. There's some icons in Zoom down at the bottom, or just wave because Barry's going to be watching and he'll interrupt me and I will take the questions. Because you know, it's hard enough on Zoom to get interaction. And if I just pause for questions, and people might not have something in mind, but if something comes up immediately, please let's go ahead and interrupt me. I can keep my place going in the script pretty well. Okay, and by the way, as I mentioned once before, if you want to adjust the amount, see who's there, and you don't need the screen, the slides so big. If you put your cursor over the horizontal line between where the pictures are, where you folks are, where your gallery view is, and the slide, and you move it either left or right, you'll see you'll get more people and the slide will get smaller, stuff like that. So you can always adjust it the way you need it. As when I'm carrying the screen, I can't. I've got some of your pick. I see the first 6 people on the left-hand side and right-hand side, and that's it. Okay. The topic for this morning is religion and the Constitution. The First Amendment's Establishment Clause and the Free Exercise Clause, and I'm going to be using those phrases a lot, read, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Now, religion is deeply embedded in American history and culture. And for the past 100 years or more, the Supreme Court has been trying to figure out just what these words mean and how they apply to American life and culture. The decisions have swung like a pendulum between strict separation and accommodation, depending on the facts before the court in each case and the personal leanings of a majority of justices at any particular time. And you're going to see this because when you compare, say, the courts as they were in the 1960s with as they are now, one of the biggest differences is the law hasn't changed. It's just the outlook of the judges has changed. And most of these decisions are a matter of degree and balancing competing interests. And so you're going to get a difference of opinion that is reflected in their decisions. Now, in a 5-4 decision, here we go, the Supreme Court held that Hobby Lobby Stores, Inc., a closely held corporation owned entirely by members of one family, did not have to provide health insurance covering post-contraception services, what they call the morning after pills, under regulations that the ACA adopted. And they felt that they didn't have to do this because it violated the religious principles of the owners and thus violated the free exercise clause of the First Amendment. In other words, they're saying that because we believe that religiously that life is sacred, we don't want to have to have our company pay for morning after pills coverage for employees or independents because it violates our religious principles. That was the argument that they made, and you all know probably how it came out. Now, I'm going to start with the 1993 Religious Freedom Restoration Act. It's abbreviated RFRA, which underlies the Hobby Lobby case. And then I'm going to get into the case itself. Then to provide context, I'm going to take us on a mad dash through 3 centuries of US religious history. And finally, a look at where we are now, the recent developments and what's next. So let me begin. In 1993, Congress passed the Religious Freedom Restoration Act. The bill was introduced in the House by then New York Representative Chuck Schumer, he's now Majority Leader in the Senate, and in the Senate by Ted Kennedy. The bill had the support of both parties, the ACLU, and a swath of religious organizations that range from the American Jewish Congress to the Catholic Conference of Bishops and the National Association of Evangelicals. It passed unanimously in the House by voice vote and 97-3 in the Senate. Now, this act was a response to two Supreme Court decisions which nobody liked except possibly the justices who wrote them. The first was a case, I can't even, it's Lyng, L-Y-N-G, versus Northwestern Indian Cemetery Protective Association, and that is not a name that you need to remember. The issue there was the U.S. Forest Service allowed to build a road through lands that were sacred under local Indian tribal religious beliefs. The Supreme Court held that the government was not punishing natives or disregarding their religious beliefs, merely allowing the government to build a road it deemed necessary. The law was neutral as to religion, the road was needed, so it trumped the Indians' religious beliefs. The second case that this Religious Freedom Restoration Act that prompted it was a case called Employment Division versus Smith, 1990 case. The case affirmed Oregon's denying Smith's unemployment claim. Smith, who was a Native American, had been fired from his job working for a state hospital after testing positive for illegal substances, which under Oregon law was grounds to fire somebody. But Smith's excuse was that he had participated in a religious ceremony incorporating peyote, which is Indian tribe had done for centuries. Now, the majority opinion, which was written by Justice Scalia, held that the application of a religiously neutral law that served a legitimate state interest would not be unconstitutional merely because it tangentially interfered with the exercise of sincerely held religious beliefs. That's a long sentence with a lot of words, let me repeat it. The court held that a religiously neutral law that served a legitimate state interest is not unconstitutional merely because one impact of that law tangentially, meaning unintentionally, interfered with the exercise of religious beliefs. The problem was that these two cases overruled two earlier landmark cases prescribing a much more accommodating test. The main one was called Sherbert versus Werner, V-E-R-N-E-R, and I think it's on the list of cases. It's a 1963 case, and it held that a religiously neutral law of general applicability did violate the free exercise clause if its effect was to unreasonably burden the exercise of a sincerely held religious belief or practice. So this case said there's a balancing test. In assessing the free exercise claims, the courts were to weigh the nature of the burden on the religious belief and whether it was possible to reduce that burden and still serve the government's interest that was an issue in the law. The other case, Wisconsin versus Yoder, 1972 case, held that a Wisconsin law penalizing Amish parents who pulled their kids out of school after they finished the 8th grade, but before they went to high school, violated the parents' free exercise rights because it interfered with the parents' right to determine their kids' religious education. And this case also applied the Sherbert balancing test. It weighed how important was it that kids go to high school against the Amish traditions in terms of their religious education and their religious beliefs. And the court held that on balance, that Wisconsin should not be able to convict the parents of a crime for withholding their kids from high school under those circumstances. Now, the Religious Freedom Restoration Act was a truly bipartisan response to a unanimous belief that Justice Scalia in the majority in Employment Division versus Smith got it wrong. And this is the findings that's part of the Religious Freedom Restoration Act. And you'll see that it says that finding number 4 is that they complain about the Employment Division versus Smith. They say that the compelling interest test as set forth in prior federal court rulings is workable, striking sensible balances. And the purpose of this chapter is to restore this test in Sherbert and in Wisconsin versus Yoder. Now, it's very unusual for an act of Congress to literally recite the Supreme Court cases that it doesn't like. And the test itself, as described in the act, is really pretty simple. This government shall not substantially burden a person's exercise of religion if the burden results from a rule of general applicability, except, and the exception is, the government may substantially burden a person's exercise of religion if A, it's in furtherance of a compelling governmental interest, and 2, it's the least restrictive means of furthering that compelling interest. Now, it's interesting here, and I'll come up to this later, but take a note that the second part of this, the bottom half of the slide, are the definitions that were included in the statute. They included the word government to define it as basically every single governmental entity, both state, federal, and local. What was a covered entity, the demonstrates means the burden of going forward with the evidence. In other words, who has the risk of non-persuasion, who's got the duty to go first. And the exercise of religion means a religious exercise is defined in another section, which basically says an action comporting to a closely held religious belief. Now, the first case to interpret this statute was a case called City of Bern versus Flores. The case held that although Congress intended that the RFRA would apply to every branch of government, including state and local branches, under the doctrine of separation of powers, the Supreme Court, not Congress, has the last word on what did or did not violate the Free Exercise Clause. Now, the court's reasoning is rather complex and not germane to our discussion, but the case is important because it resulted in a large number of states adopting substantially identical state religious freedom restoration acts. And state Supreme Courts in other cases have judicially adopted the same balancing test to assess the application of free exercise clauses in their state constitutions. And this shows that almost the vast majority of states have adopted this act. Now, I'm not going to get into this case, but the facts, they illustrate something. And that is, it's frequently when the justices decide a case or when a case is decided, based on the facts, the justice will have a sense of how they want the case to turn out because they feel based on these facts, X is the desired result. And then they go around to constructing a legal argument that supports their position and ignoring legal arguments that disagree with it. Now, in this situation, the case was, the facts are somewhat weird. The city of Bern had a historic district that is set up in the middle of its downtown area to preserve the flavor of what it would have been like 100 years ago. And it required that any construction or building comply with that to maintain the nature of the historic district, which is not unusual. A lot of towns have them. San Diego has its old town. A lot of cities, Sacramento has an old town, where they try and preserve this, and they do it to bring people in, to get businesses going. It's very common. Well, in this case, the local Catholic bishop wanted to completely remodel the Catholic church that was in the historic district and basically disregard all those, the reasons why to preserve the historic district, because he couldn't enlarge the church the way he wanted to if he kept it complied with the district. So what the court did is it found that the Religious Freedom Restoration Act didn't apply to that city, and therefore the city was allowed to maintain the historic district, and the Catholic and the bishop could not rebuild the church. He wanted to basically put up a great big steel and glass mega church, which would have totally blown out the idea of the Spanish mission. And the court basically found a way to not let that happen. Now, the case, that brings us to the Hobby Lobby case itself. Now, the facts in the Hobby Lobby case were not in dispute. Hobby Lobby Stores Incorporated was a closely held corporation entirely owned by members of one family. And by the way, that's, I think that they had like 6 shareholders, and it was basically the mother, the father, their 2 kids, and siblings of the parent and a sibling. And they were all members of the same evangelical church. And the family, all the owners shared a deeply held religious belief that all life is sacred and begins at conception. Now, the store had about 500, the company had about 500 stores with about 13,000 employees who got health insurance through their employment. Now, so that's the plaintiff. The government side was Burwell, Mr. Burwell, who was then the Secretary of Home of HHW, Home and Health Services, the cabinet department that supervised the Affordable Care Act. And the Affordable Care Act, the ACA, or Obamacare as it's sometimes called, required employer group health plans to include, quote, preventative care and screening, close quote, without copays. But it left the details of what must be covered to regulations that would be adopted by the Department of Health and Human Services. HHS adopted regulations requiring plans to cover 20 FDA-approved methods of contraception, of which 4 prevented fertilized ovum from developing, IUDs and morning after pills. The ACA's regulations exempted religious employers, including churches and other religious nonprofit corporations, if their insurers made alternative coverage separately available without contribution from the employer or the employees. And there was a finding that the cost of doing this is actually negligible. But the exemption did not apply to for-profit corporations, whether publicly or privately owned. Hobby Lobby stores, the plaintiff, the owners, claimed that requiring it to pay for the cost of post-fertilization contraception violated their deeply held religious beliefs, and under the terms of the Religious Freedom Restoration Act, violated the free exercise clause. Justice Alito delivered the 5-4 majority opinion. Chief Justice Roberts, Scalia, Thomas, and Kennedy, and Alito. And he framed the opinion around 3 questions to determine if the owner's free exercise rights were protected under the Religious Freedom Restoration Act. And the questions are as follows. Does the Religious Freedom Restoration Act apply to a closely held for-profit corporation where it's entirely owned by members of the same family who share the same religious beliefs? And if the answer to that question is yes, did the ACA's contraception mandate, which includes coverage for post-fertilization morning after meds, substantially burden the owner's free exercise rights under the First Amendment? And if the answer to that question is yes, then there's 2 sub-questions. Did the ACA requirements serve a compelling state interest? And were they the least restrictive means to accomplish that purpose? Now, if the first 2 questions are answered yes, and either part of the third is answered no, the plaintiffs win, and that's how it came out. Now, on the first issue, the court said yes. Now, the RFA that I showed you, and I can go back to it right here, it includes definitions, but doesn't include the word person. Now, the Congress a long time ago, or many years, a few decades ago, passed a law called the Dictionary Act. And what the Dictionary Act does is it provides the legal definition of a number of words that are commonly used in federal statutes where no specific definitions are included in the statute in question. And these definitions do not necessarily coalesce with the dictionary definition, what we would think is the appropriate definition. And on the word person, the Dictionary Act says the word person includes corporations along with partnerships, formal and informal associations, and does not distinguish between for-profit or nonprofit corporations. Now, the purpose of this was to allow the statute to use one word to describe who or what may sue, be sued, and be subject to judicial processes. That's so that every statute doesn't have to have a long list or a separate definition. And so the opinion notes that this is fair because a small family or group that owns a business does not surrender their free exercise rights by deciding to take advantage of the corporate form to conduct business. And actually, to hold otherwise, they argue, would put a penalty on their right of free association, which is also protected by the First Amendment. Now, so that's one of the things that the opinion is relying on to answer the first question. Yes, that the word person under federal law is not what we think as the dictionary version, i.e. a human being, but includes basically the word person stands for any individual or entity that's capable of being subject to judicial processes. And so under that definition, Hobby Lobby store is a, quote, person, close quote, covered under the Religious Freedom Restoration Act. And I know that's a stretch because when we think of we read the word person, we think of an individual. But here you've got a federal statute for a specific meaning that allows it to be described differently. On the second question, let me go back to the questions. The majority again said yes. The government conceded the sincerity of the owner's deeply held religious belief that post-fertilization contraceptions violated their belief about the sanctity of life. Therefore, the requirement that they provide coverage for those medications to its employees interfered with the free exercise of those beliefs. Now, the degree of the burden was considered great because the ACA imposed substantial financial penalties for failing to provide the required coverage, namely $100 a day per employee. And if they got 13,000 employees and you're covering a lot of dependents, so that could be more than $1 million a day. If you figure it's covering 10,000 in combination between female employees or female dependents who are childbearing age, you could have up to $1 million a day. And dropping insurance wasn't realistic because it also involved a penalty. Under the ACA, if an employer dropped the health insurance, a pre-existing health plan, because he didn't like the ACA and forced his employees to go out and buy coverage on their own, if any of those employees were entitled to subsidies from the government under the ACA to pay for that insurance, the owners were penalized about $2,000 per employee under that situation. So the majority says that, yes, the burden is great because of the financial penalties that were involved if they refused to provide this coverage. Now, the government argued that the burden on the owner's free exercise was too attenuated. The word attenuated means being separated by an intervening independent cause, or where the invasion of a protected right is too contingent, too far removed from the operation of the law or the regulation that's being complained about. As the dissent noticed, and I'll get to the dissent in a minute, Quakers are required to pay taxes, even though part of them go to pay for military activities that are clearly contrary to their religious beliefs. But the courts have long held that they still got to pay their taxes. If you remember, Henry David Thoreau didn't want to pay his poll tax in Massachusetts in 1846 because he opposed to the war with Mexico, and there was a possibility that some of the poll taxes collected in Massachusetts would go to pay for the Massachusetts militia who were drafted and were serving in Mexico, which was contrary to the war. Don't do the crime if you can't do the time. And the Quakers always had to pay their taxes. The government argued that only 4 of the contraceptive means which had to be covered were post-fertilization medications to which the owners objected. And whether they were actually used or not was up to the covered employee and their doctor and might in fact never be used. Now, the majority rejected the attenuating arguments. They rejected it mainly because they said that making it possible for another person to commit an act that violates the facilitator's religious beliefs constitutes a burden on those beliefs itself. And There was no specific authority for that, but they constructed an argument that says that if the government does that, it's in effect saying that their beliefs do not have merit, which the government's not allowed to do. So that in the event, the government applied said that there was a substantial burden and it was not too attenuated, too far removed. That leaves the two prongs of the third question. The majority conceded that the ACA's provision served a compelling government interest, yet it doesn't say anything about, the opinion doesn't say anything about why it's important to provide the required coverage. Now, there's no surprise here. If you emphasize the importance of covering contraceptives, it would only strengthen the government's case that on balance, the state's interest outweighs the burden. And the court clearly wants it to be, wants people to agree with them that the balance is tipped the other way. And it's also not surprising here that all five people in the majority are men. And the people who are impacted by this, who are denied coverage, where it's meaningful, are mostly women. There's no line that abortion would be legal from the get-go if men got pregnant. I don't know if people have ever heard that before, but I think there's a certain degree of truth from it. So even though it was on the third question, they found that the interest was compelling without explaining why, the majority found that the government failed to show, as the RFRA requires, that there was not a less burdensome means that would serve that interest. In fact, according to the majority, there were very less restrictive means that could have served the government's interest and not unduly burdened the owner's exercise rights. The ACA regulations excluded religious organizations and certain non-religion-focused nonprofit corporations. So why not say the same thing could go for a for-profit nonprofit, a for-profit closely held corporation whose owners shared the same religious beliefs? The regulations could easily have done that, the majority argues. And furthermore, as the government conceded, the cost of covering the post-fertilization methods was insignificant. And taking a dig at the ACA, by the way, which Alito, Thomas, Scalia, and Kennedy all voted to find unconstitutional, so they don't like the law to begin with. The government could simply pay for such coverage as part of the billions of dollars the ACA committed the government to spend. So that's essentially why the case came out the way it did. They held that under the technical definition of the word person under the Dictionary Act, it includes corporations, that the mandate is a burden and it's not too attenuated. And even though they conceded the government's interest was compelling, that there were less restrictive ways to accomplish the purpose, the government's interest, simply by letting these corporations like Hobby Lobby be covered by the exception, or simply have the government pay for the coverage. Which brings us to Justice Ginberg's dissent, which was joined by Justices Breyer, Sotomayor, and Kagan. Now,
Arthur, a
yes.
question?
Shoot.
Maybe you're going to come up with this in the dissent, but the Quaker argument seems really compelling.
Well, yes.
So how did they address this?
How did the majority address it?
Yes.
They said it was inapplicable, that there's a difference between taxes and this is buying insurance for employees. It's, it's more direct. The taxes are more indirect. And it's not exactly a very persuasive argument if you happen to agree with the dissent. If you happen to agree with the majority, then you find that it is a compelling argument, that it is a stronger argument. Constantine, I noticed you're nodding your head. Do you agree with that? You're muted, Constantine.
I'm just laughing at the way humans, specifically the Supreme Court, put together our language, our thoughts, so that it comes out the way they want.
Of course it does.
I mean, and in that sense, are we dealing with truth or not?
Well, these issues aren't, there's no, it's all, as I'm going to get to later, a line that Justice Douglas wrote in the 1952 case, which I'm going to quote later on. Constitutional law is all involved questions of degrees and balances.
Mhm. Well, that's another way of saying we can figure out a way to get our way.
That's right. Well, in the Byrne case that I mentioned a minute ago, and let me get back to this. In that Byrne case, they decided they felt the historic district was important, and the Catholic bishop shouldn't be able to ignore it and put up a church that's going to stand out like a sore thumb. But they didn't want to denigrate and say that on balance that the historic district is more important than the church. They didn't want to have to say that. So they came up with a legal argument,
Right.
namely that the RFRA doesn't cover states, to allow them to get to the result they wanted.
Right. It's, it goes, in my mind, it goes against, the concept of the ultimate truth, which is our Supreme Court or whatever constitutional entity is formed in any country at all.
Well, there's some kind of cases there are truths. Whether or not a guy pulled the trigger and killed somebody, you can have a truth in that. But whether or not a governmental interest outweighs a religious freedom issue, but there's no truth that's irrelevant.
But anyway, to your example, what we say, yes, did he pull the trigger? Then we ask why.
Right.
And why then governs the punishment.
Exactly. Well, not only covers the punishment, but it may cover legal justification.
Exactly.
Mitigation.
Like you're protecting yourself and blah, 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 like we do. Anyway, so that's all.
Okay.
That's why I'm shaking my head.
Okay. Let me go on. Now, I read Justice Ginsburg's dissent as having three main arguments. And by the way, if you ever read this case, and it's about 40 pages, each opinion, both the majority opinion is about 30 pages long, and Justice Ginsburg's dissent is equally long. So it's a slog to get through. But just as Justice Alito's majority opinion dismissively rejects Ginsburg's arguments, her dissent points out the failings of the majority's reasoning in the strongest possible terms, short of saying, "You idiots."
Well, then I agree with her.
Her dissent makes three main arguments. First, the majority is dead wrong when it interprets the RFRA as being an intent by Congress to significantly move federal policy to expand free exercise rights to include owners of closely held for-profit corporations. Rather, as noted in the findings Congress included in the first part of the RFA, the law was simply there to restore the balance test that existed before the Supreme Court threw it out in Employment Division versus Smith. Congress didn't intend to expand the class of entities covered by the act to include for-profit enterprises. No Supreme Court case has ever held that a corporation could claim that it had rights under the religion clauses, let alone that some rights were violated. And she just ignores entirely Justice Alito's reliance on the Dictionary Act. She just thinks that, she says, you're just fooling yourself, that person should mean person. This isn't a technical act. Next, for a number of reasons, the majority got the balance test all wrong. The supposed burden is too attenuated. It's too far removed, while the government's interest is enormous. To paraphrase the line, one of my favorite lines in The Wizard of Oz in the movie is when the coroner comes out and he says, I certify that the witch is not merely dead, she's sincerely dead. Well, to paraphrase the line from that, the government's interest is not merely compelling, but sincerely compelling. And the reason is the regulations of the ASA recognize that availability of contraceptive services allow women to control their reproductive lives so as to participate equally and socially in American life. Yet the claim burden on the owner's free exercise rights involves paying but a tiny fraction of the overall cost of providing health insurance that covers a huge variety of medical needs. And she says there's no difference between a Quaker's objection to paying taxes because part of the money goes to serve war aims, which their religion forbids, a claim that the Supreme Court has consistently rejected is too attenuated. There's no difference between paying, several thousands of dollars to cover 13,000 employees, of which pennies go to this part of coverage. And it's a coverage that you have nothing to do with, it may never be used. Furthermore, not every employee will choose to have this coverage. She also, and this is really important, takes the majority to task for seeing only competing interests as involving the government on one side and the owners on the other. This ignores the fact that the community to be considered in balancing the government's interest against the burden on the owners' religious beliefs include the interest of the thousands of women and their dependents who don't share the owner's religious beliefs, who will still be denied contraceptive coverage. And it's well-settled law that the owners of employers are not allowed to impose their religious tests or criteria on their workforce. And in effect, this is what's happening. Allowing Hobby Lobby to exclude contraceptive coverage from its health plan for religious reasons imposes the owner's religious beliefs on women when determining what form of contraception will be included in their health plan. It's a very logical argument. In sum, the dissent argues that the majority is wrong on the law, wrong on the facts, and has made a decision of, and I quote, startling breadth that commercial enterprises, including corporations, may, along with partnerships and sole proprietorships, opt out of any law except tax law that they judge incompatible with their religious beliefs. That is the Hobby Lobby case and its dissent. So there we are. That's what the case is about. And it caused a storm when it came out. But I wonder, the majority opinion does one thing. It states, and it specifically states, I don't know if I said this, the majority opinion says specifically, this opinion does not has nothing to do with publicly held corporations, which is where the stock is held, or even privately held corporations with diverse ownership. Here you have a corporation with less than 10 owners, all of whom are in the same family and all of whom belong to the same church and share the same religious beliefs. In effect saying, hey, this opinion only applies to this case and something very like it. Don't read it any broader than it is. And Justice Ginsburg is saying, you can say that, but the perception of this is going to be, and if you open the door this far, it's going to keep getting wedged open more and more. So that's the Hobby Lobby case. Are there any questions? Anybody got any questions or comments that they want to throw out about it, or anything they need me to repeat or that they didn't follow? Yes, Constantine.
Well, I thought that after the case was adjudicated, there were some states, I guess, who didn't accept the insurance program based on this.
There were some. Well, the states had no choice but to accept the program. What they did, some of the states objected to and didn't do, was to expand their state Medicare, the state the state plan for dealing with with needy people under what we call Medi-Cal.
Right.
Their state versions of Medi-Cal, not Medicare, but medical services would not be covered.
Okay, I'm sorry. Yeah,
and that's what the states did. The states could not, and those states did not, and other states did not have a statewide market. So they had to rely, people in those states had to rely on getting insurance through the federal marketplace. California has a very active marketplace with a lot of companies involved in it. So people in California, and California does, of course, cover it tremendously. Susan, did you have your hand up? You're muted, Susan.
When they talked about burden, it was only a financial burden. It seemed to me that the burden was, the question of burden would be whether it affected their their ability to practice their religion, and I didn't hear that come into it at all.
They didn't discuss that. That's not in there. They said there's different kinds of burdens. You can burden a person in terms of preventing them from practicing their religion, or you can impose a fine, or you can impose a financial penalty, which is also a burden.
Right, but I guess it would seem to me, of course, from the Ginberg standpoint, I suppose, that the test should be whether they're able to practice their religion, which is the basis of the case.
Well, except that if you put a price on establishing your religion and practicing your religion, if you, like in the Yoder versus Wisconsin versus Yoder case, where the issue was if you didn't send your kids to high school, the parents could be convicted of a misdemeanor. Or subjected, or so a financial penalty is considered a burden under law.
Okay.
And there's nothing in the RFRA that defines burden any narrow.
Any other way, okay.
And one other, on this question of person. So if a business is a person, who speaks for that person? I mean, if somebody in the Hobby Lobby family didn't agree with the rest of the family, would that create a complication for this concept of person equals a business?
It wouldn't be a complication in terms of person, because remember, the word person in a federal statute is not necessarily the dictionary definition of person, but the definition of person under the Dictionary Act, which basically defines person as any individual or entity who is subject to, on a singular basis, to judicial processes. In other words, to be brought into court in the name of the entity.
How narrow was the decision making? Was it restricted to a company like this, a family company like this? Because if so, that's not really to do with the definition of person, because the definition of person in that dictionary is much wider, but they seem to only be talking here about a type of company that's a small family-owned company.
That's right. And the reason why is that even if the word person only goes to the first of the three questions. The second question would then be, is there a burden? And if you have a person that doesn't share the same religious belief, then the second question is answered no, and the case and they lose.
Mm-hmm.
So the word person only goes to indicate whether or not and they said, we are only interpreting this to mean that a corporation such as this one is like this one is what we're talking about, and is before the court. And here it is. The opinion emphasized that the holding in this case applies only to corporations whose owners, that's a closely held corporation, whose owners share the same religious views. And they specifically state that questions involving publicly held corporations or corporations with diverse shareholders is not before the court.
Not before the court. Mm-hmm.
And that's laid out in the opinion.
Roger?
Yes, Roger. Unmute yourself, Roger. Thank you.
Sorry, we're all still making that same mistake after months and months. I'm just kind of curious whether the word harm ever comes into this rather than burden. I mean, when access to certain kinds of care are denied to women based on religious principles of someone else, or when education is denied to children because of the religious beliefs of the parents, doesn't that cause harm to these people? And does the religious belief kind of supersede the harm it may cause to others? Is that ever a consideration?
Well, I'll answer that in two parts. First, as to the law is pretty clear that as to minor children, the parents have the right to supervise their religious education. So and that was the in Wisconsin versus Yoder. That was the holding, and that is part of the free exercise right, is the right of a family, of the parents, to control the minor children's education. Now, if you're talking about a 16-year-old kid, or who's a 17-year-old person who may be a minor for another 6 months, then you're getting to the gray area. You're getting the gray areas. But the other part of your question is that the religion cases have all talked about the idea of the burden on the religious exercise, because the First Amendment says Congress shall make no law that respecting an establishment of religion or prohibiting the free exercise thereof. And whether or not the free exercise is being inhibited has been described in terms of being a burden on the free exercise of religion. Whether or not that exercise of that burden harms somebody else would be considered as part of assessing the nature of the compelling governmental interest on the other side. And what Ginberg is saying is that if you limit the balance to only include the government on one side and the individual and the plaintiff on the other, you need to also think about who the compelling interest, what does the compelling interest serve? What people does the compelling interest serve, and put their interests into the balance. And then the word harm would come in that sense.
Did the Supreme Court consider whether the government had alternatives that would allow the company to continue, to refuse to cover these people, but the government would find a means of covering them? Did they take that into account?
Yes, Jess, I said that. I pointed that out in the response to question two, the last question. Was there an available means that the government had to serve the compelling governmental interest without burdening the religious exercise? And the answer, and Justice Alito in the opinion says, yes, there were. You could have simply included in the exemptions closely held corporations whose owners share the same religious belief, along with religious focused nonprofits, or because it involves only pennies, the government could pay for it.
And what I'm getting at is, did Ginberg and the others take that into account in their response? What was their answer to that the government had an alternative?
Their answer to that was, you don't have to go that far because it's too attenuated to be a burden, and they shouldn't be covered. They're not covered by the act.
Oh.
And that question, the answer to that question then becomes is irrelevant. And I think she also pointed out that telling the government to pay for it is not an alternative way, because then all the other taxpayers are paying for it. Okay. I've got 7 minutes of 10. Shall we take a break now and come back, say, at 10 o'clock? Is 7 minutes a long time?
11 o'clock.
11 o'clock.
Good.
Okay.
Hmm. You know, Arthur, I think sending out the little reminder makes a difference.
Yeah, we seem to have more people today.
Yeah, we've got about 50% more people.
Yeah, let me see, I can tell you, we got 25.
Well, it was up to, it's been up to 30.
Oh,
And then
okay.
there are multiple people in some of the devices too. So, yeah.
I see some people have some chat up.
Yeah, you might take a look at.
I'm looking at them right now.
Mhm.
When Joe comes back, what justice of the present court do I look favorably upon?
Well, mm.
What is caption transcript?
Well, I think the voice recognition might possibly run a closed captions thing underneath. I've never tried it. I'm not sure.
And I'm afraid of it because it doesn't do punctuation. It's not like you get on television.
Yeah, I'd be a little concerned that it would be very distracting.
I know that when I taught at Cabrillo, I took a course in how to teach online, and because of the ADA, the American with Disability Acts, if instruction includes a video, you do have to include the script available. But it's a lot of work to do because I've done it. And the voice capture first off, it doesn't recognize every word. It picks up every sound that you make. It doesn't have any punctuation. And it takes hours to literally edit it down to a decent script.
Mm.
So I'll explain that when Joe comes, if that's what it is. And yes, I work from fairly complex notes that are almost written out because I want to make sure I stay on point and I cover the points I want to make, but I depart from it, and I'm not about to send it. It's not something that I would send out without a huge amount of work with footnotes and everything else.
Mm-hmm.
Joe, if you want to turn your camera on, I can answer some of your questions.
Arthur,
Yes, Susan.
I missed the Citizens United case when you presented, so I'm a little ignorant. What this is the question of personhood? I heard of that one as well. Isn't that fundamental to what we're talking about? Who is a person and who is not?
That did come, the personhood came out in that case, but it wasn't, personhood didn't come out in terms of the definition of a federal statute.
What's the difference?
So that the Dictionary Act wasn't there was no assertion in the Citizens United case that the word person is controlled by the Dictionary Act. What the majority went on in that case is that the right of free speech applies regardless of that the right of free speech applies to associations as well as to people as individuals.
Okay, but doesn't that involve the definition of persons?
Not necessarily.
Okay.
Because the word person, the argument is that in the Religious Freedom Restoration Act, the word person is a statutorily defined term.
Okay.
In the First Amendment, person is an all-inclusive term to include those who, what does the First Amendment protect, and does it make a difference who the speaker is? It's not a statutory question. There's no, the definition of person in the Dictionary Act is not necessarily relevant.
Okay.
So much of law is and you get used to the courts drawing distinctions. And sometimes they don't always make a lot of common sense. They may make sense in terms of the application of a particular statute or a concept, but they don't make but they depart from common sense when you take them out of that context.
Exactly.
Okay, I see we have a lot of people have their cameras off. I don't know if they're here or not. I'll wait one more minute. Joe, the other question you had, you asked a question about caption transcript. Joe, are you there? Don't know how to turn my video on. In your lower left-hand corner, if you put your cursor over there, you will see there's a little picture of a microphone, and next to it is a little picture of a camera. But that says there should be a line drawn through that, which means your video is not on. If you click on that, your video will turn back on. Joe, you're also muted.
Mhm.
Barry, have you muted everybody?
Yeah, and I'm not able to unmute people.
All right, so you have to unmute yourself.
Yeah. And
In
also
any event,
that bar down below often won't appear unless you pull your cursor to the bottom of your screen. Otherwise, it will be hidden.
right. Okay. Joe asked whether or not I could provide a captioned transcript, and the answer basically is no. There is voice recognition built into this, but it's really, really lousy. It picks up every sound, and it would take forever to edit it actually to the point where it would be useful, because it'll misunderstand words. It's not very accurate. It doesn't have punctuation. I've had to work with it before when I taught, and believe me, it's not worth the effort. Especially given the huge amount of money that I'm getting paid for giving this talk.
That's right.
Will corporations ever be stripped of their personhood? The answer is probably no. Can I recommend podcasts which are focused on the Supreme Court rulings? I really can't, because I'm not a podcast person. I read magazines and newspapers and books, and I'm old fashioned. I'm not a podcast listener, so I can't really recommend any. Susan, you have your hand up.
There's one called Sisters in Law. It's excellent. Sisters in Law.
Sisters in Law. Okay.
Yeah. I can't give, there's, I believe, 3 commentators. I can't give you the names of each of them off the top of my head, but they're very good. I recommend it.
If one of them is Linda Greenhouse, I highly recommend it. She's
It happens not to be, but they're all excellent.
okay. Which justices of the present court do I look favorably upon? Well, unfortunately, Ruth is gone. I like Elena and Sonia. I like Breyer. No, I'm not really very happy with all the others. I would not have appointed them. I probably would have voted for any of them if I'd been in that position. Okay, Barry, I think it's time to get going again.
Mhm.
Now, what I'm going to do in the second half is I think that it's important to have a sense of how religion has been and is woven into American society and culture. And it'll help us understand why for the last century, the justices have been strongly divided and their decisions involving religion have been inconsistent. And that inconsistency is due in part to the degree in which religion has been in the forefront of American society and culture, literally from the very beginning. Pilgrims and Puritans came to New England so they could establish communities where life was centered on enforced communal observance of a singular and exclusive set of religious ideas and practices that included mandatory weekly attendance. If you disagreed with them, you got kicked out. They hung Quakers who were banished and coming back in 1639. Roger Williams, because he didn't agree with the preachers involved, was tossed out and had to go start New Rhode Island. Concurrently, by the middle of the 1600s in early Virginia, colonists were required to both financially support and attend the Anglican Church, which quickly became the center of social life. Elites used it to solidify their status based on social norms that prioritized wealth, land ownership, and race-based slavery, all tied into religion, to church attendance. And starting in the 1690s, the North American colonies were required to honor the Brit Parliament's Toleration Act. And as a result, starting in the 1690s, you had different organizations, churches organized around the Congregational, Anglican, Presbyterian, Baptist, and Methodist denominations all flourished and grew, and collectively they stayed at the center of colonial life. During the 1740s, I'm going to share my screen here. During the 1740s and 60s, the colonies were swept up in evangelical revivals of religious fervor, later be called the First Great Awakening. Dynamic preachers such as Methodist George Whitefield, who's depicted here, and by the way, yes, his eyes are crossed, that's the way he supposedly was, became popular idols. Reportedly, crowds in the thousands gathered to hear him. Although many of the founding fathers professed to be deists or generic Christians, they were in a minority. The demand for a constitutional amendment that assured religious freedom was not to prevent atheists or agnostics from being ostracized. Rather, James Madison's initial draft of the proposed amendment made it clear that a large part of it was intended to prevent the new national government from selecting any one denomination as a national religion. And if you look at this, this is where Madison proposed, and I think I mentioned last time, 16 different proposals to be added as amendments to satisfy the demand for a Bill of Rights. And what we see now in the First Amendment, the Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof, was basically a rewrite of this. The civil rights of none shall be abridged on account of religious beliefs or worship, nor shall any national religion be established, nor shall the full and equal rights of conscience be in any manner or in any pretext infringed. Madison was not known for brevity. The amendment was designed to prevent one Protestant denomination from gaining a more favored position when and if its adherents were in control of the apparatus of the new national government. And it's also important to note that several states at the time when the new Constitution was adopted, literally had established religions in the sense that public taxes went to pay for their upkeep. The Anglican Church was supported in several southern states in the sense that people who lived within the parish were required to parish taxes collected in the parish went to pay the minister. In the New England towns, the townships, the Congregational Church was established under Massachusetts law in the sense that it received taxpayer money to support it. The last established church was stopped in the United States in the 1820s. For most Americans, church membership and regular church attendance was the norm, and it remained the norm during the 19th century and much of the 20th as well. As one historian has put it, for much of our American life, America has been awash in a sea of faith. That's the title of a book by John Butler that goes into a lot of the early religious history of from the 16 and 1700s. Let me give you some illustrations of this. Upon touring America in the 1820s, Alexis de Tocqueville noted, quote, "There is no country in the whole world in which the Christian religion remains a greater influence over the souls of men than in America." Close quote. Historical records of the number of churches and the number of Americans who regularly attended them confirm this. Next, every state constitution written and rewritten since the break from Britain exempted churches and church-owned property from taxation, although state and local governments primarily relied on property taxes to support themselves. Remember, there was no income tax until 1913 when the 16th Amendment was passed. During the 1830s and 40s, 100 years after the First Great Awakening, America was swept up in a second wave of evangelical revivals, such that ministers at the time called it the Second Great Awakening. It was so pervasive in upstate New York that they called upstate New York the burned over district. It literally one revival after another. I can tell you a little story about this. You know, the Erie Canal was a major thing. I've actually taught courses on this. And unfortunately, it froze up every year from about November through May. The Erie Canal was closed. And travel was very difficult in the wintertime. So what did people do? They went to church. And church attendance grew up. And during this period of time, religion and religious revivalism was huge. Rochester is an example. I mean, in 1815, there were 1,500 people living where Rochester, New York is. By 1840, they had almost 30,000. You can imagine what that kind of growth in that kind of period like. And there were so many churches in Rochester, they figured there was one for about every 30 families. That's a lot of churches. The first credit reporting agency, a quarterly journal that started in the 1840s, published lists rating businessmen on their creditworthiness. Now, starting at this time, up until the 1820s, 30s, 40s, and 50s, most people, 90% of business was conducted within 10 miles of where the businessman lived. That's where the business was. But with the development of canal transportation and then railroads, you found much more of the merchants in the cities, in the East Coast cities, needed to know who in the hinterlands they could do business with. So there was a credit reporting company that was put out by the Tappan brothers of New York. And it was interesting. They rated businessmen on their creditworthiness, but they didn't focus on or ask questions about, do they pay their bills on time? The questions that were asked is, are they churchgoers? Do they belong to a congregation? And do they have a reputation for sobriety? That was more important than whether or not they paid their bills on time. Religion was a huge part of slave culture, where the Old Testament stories of Moses and the Exodus became combined with the faith in Jesus that would bring freedom. And to this day, in the African-American community, the Black churches are a very central part. Henry Louis Gates had a series on PBS, a special on PBS on this that was fascinating to watch. If you can, any of you can get it, if you missed it, it's worth the time to see. It's excellent. By the 1880s, the American South, especially its rural areas and small towns, became known as the Bible Belt. During the 19th and early 20th centuries, most Americans learned to read from biblical stories in the King James Bible, and schools often had students recite the Lord's Prayer at the beginning of the school day. Teaching Protestant values was said to go hand in hand with teaching American values. And virtually every public function from the lowest community level up to every time Congress was called into session began with a clergyman-led prayer. And group revivalism have always been a part of our culture. That the 19th century camp meetings on the frontier are almost identical, they're the common link to the mega churches that dot our suburban landscape, especially in the South, Midwest, and Sun Belt. And Americans at the highest levels invoke religion and religious values to explain, understand, or hope for success in any number of instances in our history. Lincoln's second inaugural address is essentially a sermon explaining that the death and devastation of the Civil War was visited on Americans by a providential God for the sin of slavery. How many of you were old enough to remember FDR's going on the radio and announcing that the Americans had landed in Normandy? And if you remember that, he gave that speech was a form of a prayer to ask Americans to a prayer for divine intervention to bring success and protection to our soldiers. I don't know if you remember that, but if you Google it, you'll see that was Roosevelt started it. Oh, Heavenly Father, we pray for the success of our troops and their cause. Now, I've tried to show how throughout our history, religion and religious observances were and are part of our lives and identities, with Protestant Christianity most common by far. According to polls in the late 1980s, over 95% of respondents expressed a belief in God, and 60% of respondents regularly attended public worship. Compare this to Western Europe, where in similar polling at the same time, 40% of respondents claim not to believe in God, and less than 10% regularly attended church. Now, we are far from being a secular society, even though church membership and weekly attendance have declined over the last 40 years, but they haven't declined so precipitously as to make us a secular society. And this has had an effect on our courts. Before the 1920s and 30s, the Supreme Court was rarely called upon to decide cases based on the religion clauses in the First Amendment. Remember, the Barron versus Baltimore held that the Bill of Rights didn't apply to the states, and Congress passed few to no laws that touched on religious or religious organizations. But in the 1930s, the Supreme Court began the process of what they called incorporation, holding that certain provisions in the Bill of Rights that were fundamental to the concept of ordered liberty, and that's in quotes, were incorporated by the Due Process and Equal Protection Clauses of the 14th Amendment, thereby making them binding on all sections of government. And in the 1940s, this doctrine of incorporation was held to include the religion clauses, the free exercise and the establishment clauses. The first free exercise cases involve Jehovah's Witnesses. Now, Jehovah's Witnesses, they object to their children being required to salute the flag or to recite the Pledge of Allegiance because their faith bans oath-taking and saluting images other than God. And they under their religion, they have a duty to evangelicalize, to go door to door and persuade people to join their faith as part of their duty of practicing their religion. In the 1940 case, the Supreme Court held that instilling national unity outweighed their religious objection, and therefore the Pledge of Allegiance could be mandatory, did not interfere with their religious beliefs. But in 1943, on an identical set of facts, the Supreme Court reversed itself and upheld religious objections. Loyalty, they wrote, doesn't require flag salutes or pledges that conflict with one's religious principles. Now, I think the change of heart in these two cases came from being in the middle of World War II and the axis and intolerance of religious freedom. For those interested, the first one is called Minersville School District versus Gobitis, G-O-B-I-T-I-S. That word alone will get you to the case as you Google it, G-O-B-I-T-I-S. And the second case was West Virginia Board of Education versus Barnett. A third case, Cantwell versus Connecticut, also in 1940, involved a local ordinance stating that permits that allowed a person to go door to door could be denied if the town clerk believes that the applicant isn't legitimate. Now, the purpose of the statute was that so much of American marketing in those years was door to door, that people would go door to door. Bible salesman, Fuller Brush man was here. Avon calling, only I don't think Avon was there in the 1940s, but Fuller Brush was. You had Bible selling, World Book encyclopedias were sold door to door. So the idea was that the town clerk didn't want phony baloney, con men going door to door. But what happened is the guy goofed and he denied the permit to a Jehovah's Witness who says, our church requires it. And for the first time, the Supreme Court applied a standard of strict scrutiny to determine if the government's interest is sufficiently compelling to curtail religious actions in forms of observance. And it was held that the government it's not for the government to say what religious belief is or is not legitimate. Now, generally, court decisions involving religion from the mid-20th century to the present have swung like a pendulum between two views. One view is that the Constitution requires absolute total separation between church and state. Any breach will open the door to subjectivity and temporizing, which inevitably will involve someone losing rights that the First Amendment was designed to protect. And the court applied this view in the famous school prayer case of Engel versus Vitale in 1962, which held that requiring all public schools to begin the day with students reciting a non-denominational prayer, school prayer and Bible study violated both the free exercise and the establishment clauses of the First Amendment. Why? Because those who claimed the right to profess to no religion were subject to derision for their silence. And the case unleashed a firestorm of protest. One headline in the South read, "Supreme Court outlaws God." I like Herb Bloch's cartoons here. What do they expect us to do? Listen to the kids pray at home? The following year, Abington School District versus Shemp, I think I've also included this on the list of cases, invalidated a Pennsylvania law requiring schools to begin each day with teachers reading from the Bible and reciting the Lord's Prayer. In both cases, the Supreme Court noted that fusion of church and state invariably leads to persecution of dissidents, which the religion clauses are aimed to prevent. The Abington case is interesting for a number of reasons in terms of the decisions. First off, although the decision was, I believe it was 7 or 8 to 1, 4 justices filed long concurring opinions to lay out their beliefs. Justice Brennan's concurring opinion went to great lengths to explain, to cover the kind of the history that I've just covered in a lot more detail, to try and talk about the difficulty of applying these concepts in the First Amendment of the Free Exercise and Establishment Clause in a way that didn't bring them in conflict with each other, because what is free exercise to one person can be deemed establishing that person's religion to someone who disagrees, and that it also that he wanted to show that just because we say that you shouldn't have, this shouldn't be done in schools, that Jesus doesn't belong, God does not belong in the classroom, doesn't mean that we're denying or trying to denigrate religion or its role in American life. It's just in the public schools, it shouldn't be there, because the idea is that it's not just that there shouldn't be any one religion, but there shouldn't be religion in general against no religion, that too is protected. These cases, English versus Vitale and Abington School District, reveal that the Warren Court favored strict separation. Religious disputes are divisive. And as Thomas Jefferson noted when he wrote his notes on the state of Virginia, quote, "The way to silence religious disputes is to take no notice of them," close quote. Hugo Black, writing for the majority in a 1947 case, maintained that the Establishment Clause was intended to erect a, quote, wall of separation between church and state, close quote. The so-called wall of separation first appears, it never appears, that was the first time in 1947 that it had been used in a judicial opinion. The term itself is traceable to a letter that Thomas Jefferson wrote to the Danbury community of Baptists in Massachusetts, who complained that Massachusetts law established the Congregational Church, which was in effect a penalty that members of the Baptist Church were forced to pay for a religious institution they disagreed with. And Jefferson was sympathizing with their position, stating that in his view, the adoption of the Free Exercise and Establishment Clause had the effect of building a wall of separation between church and state, but he was referring to the federal government, which at that time the Bill of Rights was believed to apply to. But the Supreme Court also decided a number of cases that it was okay for government to accommodate religion in the public sphere, so long as the law or practice in question is religiously neutral, doesn't favor one religion over another or any religion over no religion. And this view assumes that those who drafted and approved the First Amendment didn't believe that religion had no place in public life, only that all religions are equal before the law, including no religion. And this approach was followed in a case called Zorak versus Clausen in 1952, Z-O-R-A-C-H. The case is not important for the facts or the particular holding. In that case, the court held that the Establishment Clause was not violated by permitting kids who had their parents released could be released from public school 1 hour a week, released from school early 1 hour a week to go to religious classes at their local church or synagogue. Even though church personnel were directed to facilitate the practice by supervising transportation, they had to make sure that, have someone outside guiding the cars. And teachers were required to accommodate students who would miss class for the last period to give them makeup assignments. Justice Douglas, who would vote with the majority in the Ingle and Abington cases, wrote for the majority here saying that this was okay. Americans are a religious people whose institutions presuppose a supreme being, he wrote, and that common sense dictates that some accommodation to the practical needs of the people is permissible as long as it's not coercive, that it's indirect, and it's scrupulously neutral. And then he says, quote, "The problem, like many problems of constitutional law, is one of degree. It's not black and white." Now, a majority of the present Supreme Court shares this accommodating view. During the same term that the Supreme Court decided the Hobby Lobby case, it decided a case called Town of Greece versus Galloway. The Town of Greece was a small town, I think, in New Jersey. The case held that opening a town council meeting with a Christian minister's prayer didn't violate the Establishment Clause. The majority noted that all local clergy listed in the town's directory were invited to participate. The people who attended the meeting were not invited to stand. It was, there was no saying, would you all please rise? And they were, or otherwise to participate. And opening government functions with a short prayer is an American tradition going back to colonial times. And this is true. From the very first session of the first Congress in 1787 up till yesterday, every day's proceeding in Congress of each house opens with a prayer. Part of the inauguration of the presidents, every time it's had, you've got somebody up there reciting a prayer to bring down God's blessing on this. The words "under God" have been added to our Pledge of Allegiance. And I think this court will continue to accommodate religion and religious institutions. In 2017, the court held that a state violated the free exercise in the 14th Amendment's Equal Protection Clause when it gave money to secular private schools to resurface their playgrounds, but didn't give any money to religious schools for the same purpose. Sometime this term, the court is going to decide a case called Carson versus Macon. Now, some areas of Maine. Susan, would you mute yourself, please? I think that's where the it's coming from. Barry, if you'd mute everybody and then I'll unmute myself.
Well, yeah, interestingly, I'm having trouble having this pop up for me.
All right, well, never mind. I'll continue.
Okay, I'll do it if I can.
Okay, well, don't, because I'm I'm sharing my screen and I can't see how to unmute myself then if I've got screen share.
Okay, I
Oh,
did
no,
it.
I see, I can do it here.
I did.
Okay, if you want to mute everybody, I can do it.
Okay, it's done now.
Okay. I've unmuted myself. Okay. As I was saying, this court's going to accommodate religion and religious institutions. I mentioned the case where it held that it was violate the Equal Protection Clause if a state gave money to secular private schools to resurface their playgrounds, but not to religious schools. And sometime this term, the court's going to decide a case called Carson versus Macon. Some areas of Maine are so rural, so sparsely remote and sparsely settled to support having a public school there. So Maine subsidizes families living in such areas whose kids attend secular private school, but they don't subsidize families whose kids attend religious schools. Now, constitutional scholar Erwin Cherminsky, who is the dean at my law school, Berkeley Law, and he's quite, if you guys have read his stuff that appears sometimes in the paper, his essays on the Supreme Court are really well thought out. He thinks this court will decide that it's okay for taxpayers' money to go towards financing religious education where no public school is available under equal protection grounds. And I think the Supreme Court will emphasize that there isn't a public school that the kids could attend. Now, my title for this lecture suggested that the free exercise and the equal protection clauses may be in conflict. An example of this is the movement among some evangelicals to prevent their children from being exposed to evolution in public school classes. Ever since the Scopes trial in Tennessee in 1925, the issue has kept popping up as school boards or state legislatures in the Bible Belt tried to bar teaching evolution because it was supposedly unchristian and interfered with the parents' right to control their kids' religious education. Recall that in Wisconsin versus Yoder, which recognized that case recognized a parent's right to control their kids' religious education, and that right is protected by the free exercise clause. This attempt to ban teaching evolution finally reached the Supreme Court in a case called Epperson versus Kansas in 1968. The Supreme Court held, this was the Warren Court, that an anti-evolutionary statute that punished people for teaching evolution violated the Establishment Clause. Any attempt to make a religious principle official policy is unconstitutional. And the justices in the 1960s seemed to believe that enforcing the Establishment Clause was more important than the Free Exercise Clause. After a number of states jumped on the creation science bandwagon, the Supreme Court in a case called Edwards versus Aguillard, Aguillard, in 1987, held that it was just another, that creation science was just another attempt to get the Genesis story back in the classroom. And it was held on, the Louisiana statute was held unconstitutional. And then came intelligent design. Well, the life is so complex and only God could make it happen. Fundamentalists who controlled a school board in a small town in central Pennsylvania required schools to present intelligent design as an alternative theory when presenting evolution theory in biology curricula. They said that both are theories. The teachers sued and the case went to trial in federal district court. It was called Dover School District versus, I can't remember the name of the other party. If you look it up, if you just look it up, Intelligent Design and Dover School Board, you'll see it. The trial lasted weeks and the teachers won. The trial court, after several weeks of trial, found that the purpose was religious. Intelligent design isn't science because it's not based on the scientific method, and it's not susceptible as being attested, and it has to be taken on faith. That's the difference between religion and science. Now, and so he said, yes, it's unconstitutional. The trial took weeks and it was expensive because the school board had to end up paying for the lawyers on both sides. And the school board that pushed this case was voted out at the next election. So the case never went up on appeal. But that's a hopeful case. Another hopeful note, I'm ever the optimist, and I can ever the optimist, was in a case called Masterpiece Cake Shop versus Colorado Civil Rights Commission. Some of you may have heard of this case. The Supreme Court had before it the issue whether a shopkeeper's free exercise rights were violated when the state punished him for refusing to provide a wedding cake for a gay couple because his religious belief was that gay marriage violated God's law. Now, the court did not go through a balancing test. It didn't rule on the issue the guy wanted. What it did is it sent the case back for rehearing before the State Civil Rights Commission because supposedly the commissioners appeared to exhibit bias against the shop's owner and bias against a religious point of view. And Dean Shermaninsky, and I will never forget this, I was listening to one of his lectures, and he said, by ducking the issue, the Supreme Court was saying that bakers can't be choosers. I love puns, I apologize. Now it's interesting, the owner in the state in Colorado settled that case, so it never came back to the Supreme Court. But only this year, the same shopkeeper was fined $500 because he refused on religious grounds to bake a birthday cake celebrating the customer's transgender status. The customer wanted a cake that was red on one side and blue on the other, on the inside, to show his status. And the shopkeeper said, by saying, I'm not going to do that, violated the Colorado's anti-discrimination law, which that says gender is a protected class. The shopkeeper has vowed to fight the case all the way, but it's still down at the state level. In June 2020, and this is the last case I'm going to talk about, a florist in Seattle was fined $100 under Washington state anti-discrimination law for refusing to provide flowers for a gay wedding. Again, she claimed that if she did so, it would violate her religious beliefs that same-sex marriage was a sin against God. As soon as she was fined, she put up a GoFundMe site and it got her $175,000 in 6 days. Now, after all her state remedies were exhausted, she filed a petition to ask the Supreme Court to hear the case and hold that her her free exercise rights were violated. But this past July, in a one-line order, the Supreme Court refused to grant certiorari. It decided not to hear the case. Just one-line order, so-and-so versus so-and-so, petition denied. That's the order. Have no idea how the justices vote on it because they don't say that. But I hope that this is a sign that the Supreme Court is not going to permit people to discriminate on the basis of race or gender when they claim that it's tied to their religious beliefs. And so that's what I think is the last thing that even for this court. And I want to leave my last word to my favorite cartoonist, Bill Waterston. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Math is a religion, and I agree with that. I was a history major, English and history major, because I couldn't get past trig into pre-calculus. And I love the last one, the free exercise. And on that note, I'm all done. And we still have some time left, and obviously, that's where we are. Should I stop sharing?
I guess so, yeah.
Okay. And the floor is open. Everybody unmute yourself.
I have a question.
Christian, Constantine, go right ahead.
Who? Which one?
You.
Okay. So this might be, you touched on something that I just wrote down here. Scrutiny of your reasoning it came out somewhere you were speaking.
Strict scrutiny. That came out in the context.
Yes, strict scrutiny. Now,
that religion is really important. And so if you're determining if a law serves a compelling government interest that justifies impinging on someone's religious freedom by requiring them to do something, you should look at that question really, really closely. It's like the difference between a preponderance, well, it's sort of that way, or it's really that way. You know, what's the difference between preponderance and evidence and proof beyond a reasonable doubt?
well, I just mentioned that because I'm going to another question. The current question now in New York State is the possession of a gun. Handguns. And one of the things that came up that struck me is that they're fighting over why you have the right to own it. In other words, there's another piece of scrutiny there. Do you have a good reason for it?
Right. And how strong is that reason?
Now,
How strong is that reason? Because where a constitutional right is involved.
right, it says you have the right to it. Now, where does it say that you have to have a good reason also to have the right?
Well, no, you don't have to have a good reason to have the right. You have to have a good reason to limit the right. In other words,
okay.
the strict scrutiny applies to how strong is the reason to limit the right. When Justice Scalia wrote the decision in Heller where the Supreme Court held, I think it was either 6-3 or 5-4. I don't remember the break in it. That the Second Amendment is incorporated by the Due Process Clause in the 14th Amendment and is therefore binding on the states. When Justice Scalia wrote that opinion, the Heller case involved the District of Columbia saying it was illegal to have a handgun in your home. And it was a blanket prohibition.
Right.
And when Justice Scalia wrote that opinion, he said, this violates the Second Amendment. That is not to say that that reasonable regulation may be required, may be permitted. He says this does not preclude all regulation of handguns, only it precludes an absolute ban on them. That's what his holding said. And I've always argued that whether or not the amount of regulation is reasonable or unreasonable is a political question. And it will depend on this court, what this court thinks is reasonable. Is the right of self-defense in the home is one thing. The right of self-defense out on the street is something else. And it's one thing to say that you can have guns in the home for self-defense because your home is your castle, but we don't want people walking around with guns and feeling they're constantly being threatened. And after all, there is a long history in our culture of local regulation being allowed. I mean, the whole idea of Wyatt Earp, that in the Western towns, the cowboys were required to check their guns before they went in the saloon.
Yes.
And so that's part of our history. And I think the issue in that New York case is going to come out is just how the judges do this. I think there's going to be a certain degree of reasonableness here, and I don't know how it's going to come out. I would hope that Roberts and one other will join the majority, will make up a majority that'll say, you know what? You got to have a reason. If you want to go carry a handgun when you're out in public, a concealed handgun and out in public, you need to be able to have a reason for doing it. I just hope that that's the way the court's going to come out.
No, but my question was, if if you have a reason that's deemed good, are we now making more, setting up our rights, in other words?
Yeah, of course you are, because not every right has certain limits. You can't yell fire in a crowded theater.
Hmm. Hmm.
There are limits, even absolute limits on free speech. There are limits that we accept as the price of living in a community of other human beings.
Okay, thank you.
Yes, Florence, unmute yourself.
I just have a comment. I remember growing up in Syracuse, New York, with the Lord's Prayer
Yeah,
at every, and by the time of high school, it was at the beginning of the assembly.
right. It was at homeroom usually.
And I never questioned it.
Right, but
It
in
never occurred to me,
1962,
nor did my parents, who were really quite left.
yeah, but
Well,
Margaret
my
Murray
mother.
McCool,
Yeah,
who was the plaintiff in the Engel case, became the most hated woman in America. She's, I'm an atheist and my kids are atheists. We don't believe in God. And if my children are forced to do this, they're being disparaged. They're singled out as being different and not worthy. And that's a violation of the First Amendment. And the Engel versus Vitale case was decided long after you graduated from high school.
yeah, well, true. There were, I remember, many Jewish kids who just put their heads down and didn't say anything. But other than that, it was just socially acceptable.
Right. When I was a kid, I grew up in West LA, and I am Jewish, and my family were Reform Jews. And you didn't go to school on Rosh Hashanah and Yom Kippur. And the problem was, where I went to school, they had a hard time having enough room, having enough kids to form a classroom because nobody was in school. It was the exact opposite of your situation.
Yes.
Now the answer is the schools are generally closed on the Jewish holiday, so everybody gets the day off, whether they're in school or not, whether they're going to temple or not.
Well, I think it depends on your community.
Yeah.
Yeah. There are plenty of places in this country. Yeah.
So
Barry.
Arthur, the other case where this comes out nowadays is in various kind of clothing, hair issues. I mean, for example, this is a big issue in France about the burqa, et cetera. So has that come up in US court cases?
It has in the military. And school uniforms have come up.
And Sikhs also,
The public school, I don't think public schools are allowed to have dress codes. And I think I don't know if it's been held. I don't know of any school district, the cases that have come as far as the Supreme Court, where they've tried to prevent Muslim kids from wearing girls from wearing headscarves. I think it's generally allowed right now.
Mhm.
And my feeling is that in the military, they have to, I believe there is some requirements that in certain situations they have to accommodate it, not in others they don't, based on the military's needs. Again, it's balanced. Yes, Lou.
Arthur, to what extent do governments in our country support support religious schools at this time?
It's the state level. That's where most of the Establishment Clause litigation now involves the issue of public money being directly or indirectly applied to private religious education. The one case that I did mention was the case that was decided where the Supreme Court did hold that if a state is going, if a local entity or school board is going to put public money available to secular private schools to repave their playing fields, to the playground, that it was denial of equal protection under the 14th Amendment to deny that money merely because the private school was organized as a religious school. So the Catholic schools were also entitled to get the same amount of money to repave their playgrounds, because the money was not going to a religious purpose at the school. In other words, the playground is the playground. Now, if the money is going to school books, would it be a violation would it be a denial of equal protection if the government said that you cannot use this money to pay for religious books, but you can use it to pay for non-religious books? In other words, would it be improper to withhold money from a private religious school that you're giving to a secular private school to buy history textbooks, or to buy Shakespeare, to buy volumes of Shakespeare for the kids, or to buy math books? And I'm not sure, I haven't quite frankly done the research to know if that question has reached the court and what the decision has been. My feeling is that it would probably, they would draw the line they would say, yeah, you can, if you can give money to cover their playground, you can give money to help them buy math books. So that's what I think this court would hold. Would the Warren Court have held that? Probably not. Because then it comes down to who the judges are. And I once did a little research. Let me see if I can find my note on it. I looked up Justice Alito, who went to Yale. He was a practicing evangelical. He was a member of the Federalist Society. He had been an attorney general in New Jersey. His advanced degree was from Seton Hall Law School, which is he taught constitutional law at Seton Hall, which is a Catholic school. He's a member of the Federalist Society. And he's used free, he believes that free speech, he's used free speech to bypass the Establishment Clause. He believes that that there is a place for religion in public life. And I think a majority of the justices that we have on the court today agree with them. Between the George Bush, Bush 1, Bush 2, and Trump, the Republican nominees they've made promises to their base, and part of their base is evangelical, that they will support justices, they will appoint justices who say there is a role for religion in public life. And I think that's something that we have to live, that our court has today, and that's what we have.
Well, my impression, I haven't done any research on this either, Arthur, but my impression is that very few public funds in any of the states or localities have been put into religious schools.
Oh, I agree with you. It's been a very small amount, but some has found their way in.
And it hasn't been tested yet in a high court, except for the one case.
Yeah, and another area where it would come in is would be in healthcare, in vaccination programs would come in, and it's not necessarily a hard money issue. Money is indirectly involved. Are there any other questions?
Thank you, no.
Okay, well, I think we're ready to wrap it up.
Okay, well, thank you all. Next time, we're going to get into criminal law. I'm not going to be talking or taking apart a current case the way I did today. We're looking at the Fourth, Fifth, and Sixth Amendments particularly. In my list of cases, I also mentioned the Eighth Amendment, but as I put the talk together, it would have been too long if I tried to include the death penalty cases in there. So I'm not going to do that. Maybe I'll do another class that specifically deals with the death penalty issue, but I'm not going to get to it tomorrow per se, unless it comes up in the form of questions. But that's what the subject is going to be. It's how the Warren Court in the 1960s effectively nationalized, applied the Bill of Rights to the states in a way to nationalize minimum requirements of the procedures that apply in criminal cases. And that's what we're going to do next time. And thank you all for your attention. I thought your questions today were great. It was a lot of fun.
Thank you.
Okay.
Thank you.
Bye-bye.